Good afternoon, and welcome to another edition of Ask Judge Carol. Today, we are talking about mortgage defaults and bank repossessions, what every homeowner should know. So, thank you for tuning in, and let's get into it. So, I want to start by posing a um, posing a question or a scenario for you. So imagine you've worked for 20 years to buy your family home. Then you lose your job, your income drops, and suddenly you're behind in your mortgage. Then you get a letter from the bank, and your first thought is, am I going to lose my home? If you've ever wondered what happens next, today's program is for you. So, good afternoon. Now, the one of the questions that will arise, as I said, can the bank take my home? And it's not, I guess, the sort of moral of the story that I would have for you today is that it's not an automatic process. Sorry, one second. Okay, I'm back. Oh, yeah, just a disclaimer before I go any further that this program, Ask Judge Carol, provides general legal information only. It is not to be taken as legal advice, and you should retain a lawyer who will go through you the particulars of your own circumstances, your own situation, and then advise you specifically in relation to your own case. So what I'm providing for you today is general information about how the law applies regarding mortgages and defaults to help you have an understanding and then inform you. Then you can ask more informed questions and get better information when you get to that stage where you are consulting a lawyer, whether you're entering into a mortgage or whether you are maybe coming out of a mortgage relationship, if you will. So, what is a mortgage relationship? With a mortgage, that is a particular kind of loan relationship where the mortgagor gives essentially title to the property to the mortgagee, who is the receiver of the property, as a security for a loan. So a mortgage is a lending relationship where there is security, and that security happens to also be the same property that the security is used to pay for the property. So most of the circumstances, if you're getting a mortgage, you're buying the kind of situation we're talking about. You're buying a house, and the bank is lending you the money to buy the house, which you are then going to move into, and you take a conveyance from the vendor in your name, and then you give a kind of you're conveying the property to the mortgagee on condition that you will repay the loan in installments. So it's like a conditional transfer of title. So the mortgagee, who is the property of the party receiving, on the condition that you pay the loan on the agreed installments, which comprise the principal amount, the amount that you borrow. So if it's $100,000, then at whatever rate of interest, the interest is applied. And so at the end of the loan, at the end of the life of the mortgage, you will have paid the principal amount plus the interest amount, which was the cost to you to borrow that money for them to provide you with a lump sum upfront. So it's a promise to repay borrowed money according to agreed terms. I'll repeat that. A mortgage is a promise to pay borrowed money according to agreed terms. And if the borrower is in default, if they breach those terms, then the lender, who is the mortgagee, has legal remedies. So some common instances of default would be missed payments. Well, that's an obvious one, because remember, the idea is that the payments are made in installments, regular timed installments of a specific amount. So there's that certainty that you're paying, $100 or $1,500 each month on the 30th of the month, and so on. It could also be a form of default, could be a failure to insure the property. It could be a failure to pay the taxes on the property or to comply with other mortgage conditions. So maybe like if there's restrictive covenants and you do not comply with the restrictive covenants on your use of that property. Think in particular subdivisions, maybe a gated subdivision, maybe not not gated, where there are rules regarding people who own lots or homes in that area, with the idea of maintaining a level of, let's call it, attractiveness for that property. And so if you are in default, if you are non-compliant with those covenants, that could lead to it could lead to the possibility that you will be open to be sued by the community for that default, which would then affect the value of the bank's security, meaning your home, and your ability to pay and their ability to recover the full value. So those are all examples of a default of a mortgage. And I think this is a convenient point as well for me to mention. So sometimes in a mortgage deed, certain categories of default may trigger the bank taking action against you. And I use action in a generic sense, not in terms of a court action, but it may lead to, for example, a court action, but it may initiate the bank writing you a letter, putting you on notice that you need to make good that default, you need to remedy that default, and to put yourself back in good standing and in good terms. And there may be obligations or incidents, things that happen as a result of you being in default. Maybe the bank, if it's something that they can fix, for example, insurance premiums or taxes, the bank may step in and pay those things, pay those obligations. I would say on your behalf, but really it's on their own behalf to keep the security intact, and then charge you, for what they paid, as well as maybe some kind of late fees or administrative fees or additional interest because they paid those sums. So it's important that in the case of a mortgage situation, that you keep the what they call the outgoings, the charges in respect of the property ownership, up to date, so that you continue to remain in good standing as it relates to the mortgage arrangement. Now, another question you may be asking is whether if you miss a payment, you're going to lose your house. Now, typically, enforcement of the terms of the mortgage arrangement is a progression, is a series of steps. It's not a one-off incident that, you missed a year paying taxes and now all of a sudden the bank is going to come after you and take the whole house, or you missed one payment. They're going to watch and see, if you miss one, or if you miss two, or if you miss 5 or 6, and so on. And then they are going to communicate with you and let you know that, hey, you've missed a payment. We need you to fix it. We need you to make the correction, make good the payment. So you may get a phone call or more likely than not, it will be something in writing, whether it's an email or a letter. And then that would be followed up with another letter and so on. So, um, yeah, so you would have, like I said, it would be a process. So it's not going to be the first time. It may be the third time or the fourth time. But, you know, when you get the letter, hopefully the first time, you will respond to that. And then after the letter, if there's been successive letters and you still haven't reached out to the bank and you haven't done anything, then you may get a formal notice telling you, okay, look, if you don't fix this, then we are going to do, if you don't do A, we are going to do B, and so on. So what you want to remember and be aware of is ignoring the problem only makes it worse, right? So, I mean, you could imagine in any normal life situation, if you ask someone, listen, don't park your car in my spot, for example, you have a neighbor and they're always parking their car in your spot, and you say, listen, don't park your car in my spot. Or if you have, something that even like with a family member, and you say, listen, I don't like this kind of orange juice, I like the other kind, and they keep buying it, then you're going to keep telling them. And eventually, you're going to be like, listen, just stop it, okay? The same way that your temperature and your irritation is going to increase in a regular relationship because someone is repeatedly ignoring your requests, you can expect the same kind of thing in the bank relationship. A lot of people, they want the bank to give them grace and forbear and not do certain things, not take certain action, but then they don't do their part in trying to be compliant or trying to communicate. So that's a general outline, as you could, you would imagine, as to the banking relationship. So you have a relationship, it's a security. You've given the house a security, and then you have an obligation to comply with the terms, and the bank has an obligation to communicate with you if there's a problem, if they have a problem with something that you're doing or something that you're not doing. So just circling back now, when I had mentioned about, if you miss a payment. So someone had asked me, well, what does the bank do? What is the bank's obligation if they have taken the house and repossessed the house? So if it's kind of a long road, let me describe it this way. It's a little bit of a long road to get from a default in paying the mortgage to a bank repossession. And we have the two pieces of legislation that really deal with it: the Conveyancing and Law of Property Act, and then more recently, when I say recently, I mean from 2017, so it's almost a 10-year-old piece of legislation, something called the Homeowners Protection Act. But in any event, there are obligations on the lender, and we're talking about a bank here, to communicate with you, to let you know that you're in default, and basically to give you an opportunity to fix the problem, whatever that problem is. Now, under the Conveyancing and Law of Property Act, and generally under the terms of the mortgage deed itself, it will allow for the bank to take possession and to exercise a power of sale. And if the bank does do that, then they have an obligation to secure the property. So if we get to that stage where they now have possession of the home, then, I mean, really, it is not in their best interest to allow the place to deteriorate, because it's going to affect what they are going to receive on the eventual sale of the property. And that's going to be their ultimate goal, is to have the property sold, because the bank is going to be looking to recover the money that it would have loaned you, they're not interested in holding on to the property for the property's sake. Now, the bank can either simply, when I say simply, use the terms of the mortgage deed itself and give you notice and then take possession of the property, or they can go through the court system, which sets out what the bank has to do in order to be able to get a judgment and an order for vacant possession. And you should be aware that it is a very difficult process. Well, it's not that it's difficult, it's onerous, meaning that it's cumbersome and it takes long. So under the Act, the bank has to give you a letter with 30 days notice, and then there are specific details that have to be included in that letter. So it has to say the nature of the breach of any covenant. So those things I mentioned earlier, whether you fail to pay taxes, whether you fail to comply with restrictive covenants, whether you are in default of paying installments, the amount of the arrears that the borrower owes, you have to specify that, the amount of any administrative costs. It has to tell you what action you need to do to fix the problem and what your rights are, including the fact that you can apply to the court for relief. And then they have to let you know that they are willing to discuss it, the situation, and a means whereby you can reach someone at the bank, because you know, and I know how difficult it is to get someone at the bank. There's no number for you to call, or you call the number and it goes to voicemail and you leave a message and so on. So on that point, I would also mention that if you are in communication with the bank, make sure you keep your records of the attempts that you make to reach out to the bank. Make a note of any phone calls that you make. If you speak to an officer and you guys are discussing arrangements, terms, or for them to give you a break. When I say a break, I mean, they're giving you an opportunity to come in and bring in information and that kind of thing. Make sure and keep a record of that. As much as possible, put the information in writing so that when you get to that point where you end up in court, whether you are the person taking the bank to court or whether the bank is taking you to court, you have something to stand on and you have something to hold on to. There's really nothing worse, in my view, than when parties come to court and they say, well, I called them so many times. And well, when did you call and who do you speak to? Well, I never reached them. I never reached anybody. You're not helping yourself. That's not helping your case. Okay? So document on your own behalf. The mortgage deed is going to require notices to be given. The deed is in writing, the mortgage is in writing. It says that notice must be given in writing, and you have to give them notice or communicate to them in writing, and they have to give you notice and they have to give it in writing. So that's the clue for you to make sure. You can call or you can make your attempts to call, but then follow it up with the communication in writing, okay? So just a note about the Homeowners Protection Act. I mentioned all of those, there's A, B, C, D, E, F, G, seven things that the bank has to include in their notice. And the courts have talked about the obligations of the bank in cases where they are seeking to take vacant possession. And one of the judges of the court just recently in 2005 gave a judgment and pointed out that the primary object of the Homeowners Protection Act is to provide protection and relief to homeowners. So the act is designed to protect you as a homeowner. So, to protect homeowners who had paid their mortgage payments faithfully for years, but found themselves in arrears and at risk of losing their homes due to the negative effect of tough economic times, whether nationally or globally, or economic times personally in your own life. So there are protections in the Homeowners Protection Act for you. But as I say, when you're going to court, even before you go to court, but certainly the idea is if you're going to court, you have the evidence of what your attempts were. So when I was preparing for this presentation and looking at some of the things that judges have said in the cases, they not only listen to what the banks have to say or what the bank's lawyers are saying, but they are hearing evidence in your case as well. So the court's job is to hear both sides and then to make a determination based on the evidence. And if you've watched any of my television shows, Justice with Judge Carroll, you will know that one of the things that I harp on is evidence, something that you can come to court with to back up your case. Now, it doesn't necessarily have to be what we say is corroboration. So corroboration is not what you have yourself said, but evidence that is from a source separate from you or outside of you that is consistent with and supports what you yourself are saying. And so keep that in mind as well in circumstances where you and the bank have fallen out, however that may have been. So I'm going to talk briefly about a particular case from a couple of years ago that was between, I'll call the names because it's recorded in the on the judiciary website, so it's public record. And this was a case between Finco, Finance Corporation of Bahamas Limited, and Philip Arlington Mitchell and Brenda Mae Mitchell. And I'm going to refer to this case, a couple of things in this case, because it was a situation where the bank had taken out filed a summons, an originating summons. So they sued, the bank, Finco, sued Philip Mitchell, I beg your pardon, and Brenda Mitchell, and they got an order, they got a judgment and an order for vacant possession. Now, a lot of times people talk about, the bank foreclosing. Foreclosure is a little bit different from an order for vacant possession. Foreclosure means that any interest that you had in the property because of the time that you would have been paying on the loan, if it's foreclosed, you're cut out of it. Whereas if it's simply an order for vacant possession, then the bank takes over the property, but once they sell it, any interest that you had accrued by virtue of you paying on it, then once they have recovered the money that they are owed, they have to pay you the difference. So that's the distinction between a foreclosure order and a vacant possession order. And many of the cases that go to the courts, the banks are applying for vacant possession. So, and then the Homeowners Protection Act, which I mentioned earlier, there are provisions there so that once the bank has gotten the vacant possession order, then the clock stops ticking in terms of the monies that are owed under the mortgage, which is a good thing to know because you wouldn't like for the bank to get an order for vacant possession, but then interest is still accruing and late fees and all of that are still accruing on the mortgage. So in a sense, also, that's why it's really a protection for you under the Homeowners Protection Act if the bank brings an application to get a vacant possession order. But as long as this matter is dragging on and the default is continuing, then your account with the bank is continuing to accrue interest. And yeah, so I remember cases, for example, sitting as a deputy registrar and explaining to someone that, listen, if the bank gets an order for vacant possession, that helps you because there's nothing else that is going to stop the clock. As long as you are operating under the mortgage deed and the terms of the mortgage deed apply, then every provision of the mortgage contract applies, and that clock is going to be ticking. And then you're going to have interest, and you're going to have late fees, and then you're going to have interest on the late fees, and so on and so on and so on and so on. So, don't be afraid if there's an application against you for vacant possession. And even after the vacant possession is granted, even after the order is made, and then a writ of possession. So there's the originating summons to start the action. Then eventually, after the trial, you get an order. You get a judgment in the bank will get a judgment in its favor, stating that yes, the court accepts that under the terms of the mortgage, you are entitled to have a judgment in your favor. So their right is recognized by the court. That's the judgment. And then the order, which is the thing that they move under, then that's the instruction, if you will, to say, so the judgment is stating that, declaring that you have the right, meaning the bank. The order says now you can go and get the house. And then even after that, the bank has 6 years before they even issue the writ of possession, which then is signed by a registrar and delivered to a deputy provost marshal, who will put a notice on the door of the house and give you notice, and it'll give you like 14 days. By that time, you would have, there would have been lots of communication back and forth. And if you're still inside the building at that point, then they're going to come and, once they put that notice on the door, they can lock you out, or usually someone is going to try and get you out of the house. I know of cases of people trying to hide inside the house. I don't understand why. But anyway, so that happens. And then, and only then, the bank actually gets possession. And then after they get possession, finally, when they physically get possession, when the bank has the keys to the house, you still have like 6 months before they can sell it. And the law says that it has to be a fair and unbiased sale. I forget what is the language, but you have to. So in other words, there can't be any like insider, what people would think of as insider trading, like trading. They can't sell it to their friend for little or nothing. Just because they now have possession. The Homeowners Protection Act gives you that protection. And so there will be an appraisal saying how much the home is actually worth. And then, like I say, if the amount of the appraisal and then the amount of the sale is more than what is owed, then you get the difference. If it's less than, then you're still liable to the bank. Now, they may or may not decide to come after you because, they may write off the difference, or it may be a small difference. It depends. But it doesn't mean that once they sell the house, you're completely off the hook, because your obligation is on the loan for the money which you got, not to give them the house instead of paying off the loan. So in the case that I started to mention earlier, I'm going to just tell you a little bit about it, because fascinating may be too strong a word, but it's an interesting case, because the bank filed an application in 2009, what we call an originating summons. So think of like a writ of summons. A writ, those are documents that start the case. in the court. You have to file a paper, and the paper that you file to start the case is called an originating summons. So the bank filed the originating summons in 2009. And then back and forth, I guess what they call pleadings were being exchanged, means that one party files a statement setting out all of the facts that they say support their case, and then the other side files a defense or an affidavit with the facts that they say, and then there may be motions and hearings and so on in between. But in this particular case that began in 2009, the bank did not get a judgment until 5 years later in 2014. So it took 5 years from the date that the bank filed the originating summons before they actually got the judgment and an order for vacant possession, saying to the bank, yes, you are entitled and you may now go ahead and take possession of that house. But guess what? Guess what? The defendants appealed. So after 5 years of waiting, basically, they finally get a judgment. And you can believe that there was activity back and forth in the 5 years, okay? It wasn't that the bank filed the originating summons, went off somewhere and went to sleep and came back, and then the court just said, okay, yeah, you can have your order for vacant possession now. Definitely it didn't happen that way, and I'm certain in this particular case that there must have been many what we call applications back and forth in the 5-year period. Okay, so finally, the bank is thinking, we get judgment and we get the order for vacant possession, but oh no, 1 month later, the defendants file a notice of appeal in the Court of Appeal. And then they ask the judge to stay the execution, to stay the order for vacant possession. So the bank got an order, but now their hands are tied. Nope, you can't go and take possession yet. They're going to appeal. So the defendants filed an appeal. The appeal was heard after 4 years. So we're now 9 years in, right? So in 2018, the Court of Appeal delivered a unanimous decision dismissing the defendant's appeal and affirming the decision of the judge that the bank could get vacant possession. But wait, the defendants then filed a notice of appeal to the Privy Council. Oh, yes. So bank's hands tied again. They filed a notice of appeal, a notice of motion which is just a technical term, but anyway, that they were intending to go to the Privy Council. But and that was in 2018. And then what happened after that? 2018, April 2018, they filed nothing. 2019, nothing. So finally in 2020, the bank says, okay, listen, you haven't done anything to move this appeal to the Privy Council forward. We are going to apply for a writ of possession, so that's like you have the order that says to the parties, yes, you can go ahead and do such and such. Now they get the writ, which is the paper, the document that is given to the provost marshal and says, go ahead, take the case, take the house. You are now authorized to do that. And so that was issued in April of 2020. So we're now, 11 years past the filing of the actual case. And then even after the writ of possession was filed, after the case was filed, a notice of motion, meaning that they intend to appeal to the Privy Council. They didn't actually appeal, but they said, we intend to appeal to the Privy Council. And then COVID intervened. So I just mentioned 2020, and you will recall in April 2020, that was when COVID was just coming on stream, or rearing its ugly head. And so then there were emergency orders, and the bank wasn't able to actually have the writ of possession executed. And eventually, when the emergency orders and so forth were lifted in January of 2021, the provost marshal then went to the property, put a notice on the property, giving them 14 days to vacate. So the people were in there all that time. Remember, I said now, when the judgment was issued, the clock stopped ticking in terms of monies that were owing under the mortgage, but they're still living in the house. And after filing an appeal to the Court of Appeal and the Privy Council, the bank then went, not the bank, sorry, the defendants then went to a judge and said, oh, it's been more than 6 years since the bank got the order for possession, so they've taken too long, and the court should throw out the writ of possession, and the bank is no longer entitled. So that's what the defendant said. Well, I can tell you that the judge was not at all impressed or amused by the defendants trying to run that argument. And particularly since they would have then had to the bank would have had to hire lawyers and go through this whole process and say that, what are you talking about? And really, the judge didn't use this term nonsense, but certainly I'm sure that would have been one of the words that would have come to the to the honorable judge's mind, because you filed an appeal after judgment was given, and then eventually after you move the appeal and the appeal is heard 4 years after that, then you file another appeal. So really it was the defendant's own actions. Mind you, they were entitled to file their appeal. They were within their rights to file the appeal, but you can't be within your right and file your appeal and then still turn around and say, oh, because I filed an appeal, the bank should not be able to exercise its judgment, which it had validly obtained. Okay, so that was the long and short of the Finco versus Mitchell case. And one of the things that the court found was that they had not suffered any prejudice as a result of the amount of time, not just the amount of time that had passed, but the way that things had progressed. So they hadn't suffered any prejudice. The court said that the issue of limitation didn't apply in their favor. And notably, the court says that the mechanisms of the court cannot be allowed to circumvent the objectives of the court in delivering justice to the bank. So that's quite a lot of information there that I've shared with you today. And I think the main thing, the key message that I have for you is really to communicate with the bank. The bank has obligations, and you also have obligations. And the best way of handling the situation is not to ignore it, but to communicate and document your communications, document the steps that you are taking. And the court will hear you if you have a reasonable argument or reasonable grounds for saying that the bank should not be allowed to repossess the home. But if they do and they sell it, they have to sell it at the best value on the market that they can get, given the circumstances, given that it is a forced sale and so on. Open every letter from the lender, respond promptly, keep written records, explore with the bank possible restructuring options, and certainly, I hadn't mentioned this yet, but obtain legal advice where appropriate. So if things are, let's say, a little sticky, or you're not making progress, or if you're beginning to feel disadvantaged or not confident that things are going the way you think they should, then by all means, you should engage an attorney. So I'm going to run through some quick questions. Can the bank simply change my locks tomorrow? I think you will see from the discussion that I've had with you today, no. The bank cannot change your locks tomorrow. And in fact, it can be years before that actually happens. Can I sell my house before the bank does? Sometimes, yes, provided the mortgage can be discharged from the sale proceeds. So if you have a sale, if you think you have a sale, the bank is going to have to basically agree because they have an interest. You're not going to be able to go away and sell it sort of behind their back because they're going to have to know about it and they're going to have to agree. But if you can find the sale, if the situation is such where clearly the house is going to have to be sold, you can let the bank know, okay, let me try and sell it before you try and sell it. And you might be able to get a little bit more for it than the bank could. But if the sale price, whether the bank sells it or whether you sell it, if the sale price is less than the amount of the debt, then you are still going to be liable for the difference unless you make an arrangement with the bank to accept whatever that particular sum is. And I think there are certain terms under the Homeowners Act that will govern that. And if you are in that situation, certainly that is something that you would want to speak with your lawyer about specifically. So if there's any question of defaulting on the mortgage, that's a great opportunity to, on occasion, to take legal advice for your own particular set of circumstances. So that's what I have for you today. If you have questions generally around this topic and you'd like some more guidance, then you are free to book a session with me. You can go to my website, www.judgecarol.net, or send me an email, info@judgecarol.net, and you can book a 20-minute consultation. Terms and conditions apply. If you reach out, I will provide those conditions. Okay? And thanks for your time. I look forward to seeing you for another session of Ask Judge Carol Live.